Hi, today we'll be talking about the written statement on oath of a witness, which is one of the documents that's front-loaded by a claimant and also by a defendant in actions commenced in the High Court. So as you can see on the screen here, the written statement on oath of a witness is a deposition on oath made by a witness before the commissioner for oaths. Now, you know that at a trial, right, at a trial in the court, the party at the trial would call witnesses to prove his case. Now, your witnesses are supposed to come and give testimony to the court, all right? They go into the witness box and then your lawyer is supposed to ask them questions which would enable them to give their testimony to the court. And after your lawyer is done, the opposing counsel would come and then also try to basically discredit the testimony that that witness has given. Now, you see that in order to save time and the court's time and to make proceedings more efficient, the rules of court stipulate that before your witness is brought to the court, you should take your witness before the commissioner for oaths, all right, in the court registry, and let the witness make a sworn statement before the commissioner for oaths. The sworn statement the witness is making would basically be the witness telling the entire narrative, the entire story of the facts as is known to the witness. And then when the witness is brought to court to testify, after the witness is taken into the witness box and is sworn on oath, after your lawyer has put some introductory questions to the witness, for instance, asking about the witness's name, their address, then the lawyer would usually now begin to question the witness in this line of questioning. So the lawyer would say, do you recall making any statement? And the witness would say yes. The lawyer would ask the witness, where is that statement? The witness would say, I believe it's with you. And the lawyer would ask the witness, if you're shown the statement, would you be able to identify it? Would you recognize it? And the witness would say yes. The lawyer would say, how can you do that? And the witness would indicate that they have their signature at the bottom of the statement. And then with the court's permission, the lawyer would now show the statement to the witness, and the witness would identify it as their statement. And then the lawyer would ask the witness, what do you want to do with this statement? And then the witness is supposed to say, I want to adopt this statement as my oral evidence, as my oral testimony for this trial. And after the witness says that, the lawyer would now inform the court that witness has applied to adopt their written statement on oath as their oral testimony for the trial. And after that, the lawyer may not need to do any further elaborate questioning with the witness except to tender any documentary evidence through the witness if there is any that needs to be tendered. And the opposing counsel can then come and begin to cross-examine the witness based on what's contained in the statement. So for instance, the opposing counsel can say, witness, in paragraph 4, you said so and so and so happened. I put it to you that you're lying. This did not happen. Okay, so the statement becomes a part of the court record, and the opposing counsel can start to cross-examine the witness based on that statement. So the witness statement on oath is the oral testimony of the witness at trial. Now, something you would see in questions sometimes in exam scenarios is where the witness is confused on what to do, where the lawyer would say to the witness, what do you want to do with the statement? And the witness is saying, I don't know, you're the lawyer, you should know what to do with it. Now, where that happens, what should the lawyer do? Now, the proper thing for the lawyer to do would be to ask the court for a recess, for a short break, a short adjournment, and then inform the witness on what the witness should do, all right? That the witness should adopt the statement as their oral testimony. Now, what the lawyer should not do would be to adopt the statement on behalf of the witness. only the witness can adopt their statement on oath by themselves. So I hope you've learned something about written statement on oaths today. I'll see you another time. Bye-bye.